Hi, guys. It's Kathy. I hope you're doing well. We made it through music bingo. That's what Wednesday is to me. Tuesday is trivia. We made it through trivia. Tonight, music bingo. And I got home from work. And on my front porch was something from Australia. I got a package from Australia today. Let me show you what was in it. It was from CJ. Thank you, CJ. Okay. This is very important. It's a stress ball. I need that. I absolutely need that. Even better. Chicken salt. Chicken salt from Australia. I can't wait to try that. I really can't. 4 packages of Tim Tams Cafe Latte, Decadent Triple Choc, Dark Choc Mint, and Salted Caramel Brownie. Okay. Those are really good. Those are really good. Right. 2 of these things I know. The third one I don't know. And I need help. The first one, it's a kangaroo she crocheted for me. Look at it. Oh my God, it's so cute. The button eyes, it is so cute. And then it gets even cuter. I'm unsquishing it first. It's a koala bear with a little koala baby on top. Isn't that great? Oh my gosh. Now this next one. What do you call this one? I'm hoping it's something just exclusive to Australia. What is this? CJ, you were here. Where are you? Is it a dodo bird? Oh, a kiwi? Oh, it's a parrot called a gala. All right, I probably said that wrong. Gala. Gala. It's a gala. That's the best I can do. And now, all that stuff was really good, but there's more. It's the best part of the package. I haven't tried it yet. I need to find the right bread. I need to plan this out. I need to do it right. But Vegemite. Look, it's see-through so that you can see exactly what color it is. She sent me 2 packets of Vegemite, and I'm so excited to try this. I need to get the right bread. I need to toast it right, and then I'm going to eat Vegemite. Oh my gosh, I did always want to try Vegemite. What if I like it? It's possible. Lots of people eat it, so lots of people do like it. I could be one of them. I could just be a Vegemite. Yeah. All right. White bread, toasted butter, and the tiny, just scrape it across. It's like a vegetable spread. I think it's vegetable because it's called Vegemite. It's like apple butter, Kelly, only not apple butter at all. It's very salty. Well, so am I sometimes. So we're sticking with our YouTube judges because that's what we're going to do this week. And it's only Wednesday. So we have 2 more days of it. And I hate it. I'm not going to make it to the end, guys. I'm pretty sure that I'm not going to make it to the end. This might be our last day of YouTube judges. I don't know. Oh, maybe it does. Maybe my toilet will go. Woo. Right. So this is kind of nice. I haven't seen him in a long time. It was kind of nice to see him again. I actually don't know how many of you watch. I don't know what you guys watch when I'm not streaming. I don't know if CJ, thank you. Thank you so much. I'm blown away. It is awesome. I can't wait to turn my camera off and eat a whole package of these Tim Tams Deluxe. I'm certain that all of you know Judge Middleton, right? If you don't know Judge Middleton, because I never ever play Judge Middleton, I did way at the beginning. But if you don't know who he is, just say so. Oh, press play on you, sir. Okay, just in case you don't know who he is, just real quick. Judge Middleton is a judge in a small town and he knows everybody. And he has stories about everybody and their fathers and their mothers and their brothers. Debbie Davis is the prosecutor and she's amazing. Debbie Davis is just so good. And we're going to see her here today. Don't worry. She looks very librarianish today, guys. I don't know if she's like this is what she looks like now. Or what, but she looks like a school teacher in this one. I love her though. I love her so much. Here we go.
My office and I was like, hey, guess what?
Yeah.
Hey guys, I was confused. Felt like a compliment.
Good morning, everybody. Everyone's a couple minutes early. Thank you for being here. This is the time and date. For our recorder not to work. I think Laura just stepped out too. Work this morning. Something. Now I have Casey is here. I'm not sure what that's about. camera out.
You want me to call IT?
No, I don't need IT, I just need.
Okay.
A hammer. Usually Michelle's here to tell me, hey, your light's not lit. That would have been Paul's job. All right, let's try this again. This is the time and date for the sentencing in the matter of Peoples versus Ricky McCall Matthysse. Mr. Matthysse is here, also present, and his lawyer Casey Strong. Prosecuting attorney Deborah Davis is here, and Matt Huff is here from the probation department. Matt and I have had a number of discussions about this case. Mr. Matthysse had 2 drinking driving instances in a short period of time. This incident occurred in March of 2025. Defendant entered a plea of no contest to operating while impaired, I believe is the way this went. And the matter was referred to sobriety court. Matt has spent a lot of time on this. I think Strong has as well. Anyway, troubling set of facts, troubling circumstance, and some logistical issues that which could be roadblocks. Ms. Strong, what would you like me to know?
Thank you, Your Honor. In review of the report provided by Mr. Huff, I would like to thank Mr. Huff and the sobriety court team for all the work that they have put into this, and recognize that Mr. Matthysse did complete the evaluation with Spencer yesterday. They had a 3-hour meeting, and it's my understanding that Spencer was going to contact someone with the court to have a discussion regarding that. If the court has received that communication, is prepared to move forward today, we can do that. Otherwise, if we are still waiting on that report from Spencer for possibly qualifying Mr. Matthysse for sobriety court, I would ask for an adjournment. Mr. Matthysse is 23 years old, and the court has looked at the set of facts and has noted that there are some things that they're concerned about, which makes Mr. Matthysse a candidate for sobriety court. And my knowledge of sobriety court, it's a wonderful program that will allow Mr. Matthysse to rise to the occasion, participate in the program, and get back on track. We all know, and we can all relate to the fact of not having a driver's license and the impact that can have on employment, schooling, the rest of his life until that gets resolved. And not only the driver's license participation issue, but also just having some kind of a support system to get plugged into young to address this and resolve this issue before he goes forth into the world. Mr. Matthysse retained me on this case. He has been early, he has been communicative, he has been present for every court hearing and every communication. I think that he would take this Friday court participation very seriously, and I would ask the court to consider him for that.
Debbie, before I hear from you, let me tell you what my concerns are. One, I'm not sure Mr. Matthysse is mature enough to do this. We don't have the greatest track record with very young people, although we just had a very successful young man graduate at 24, and he started the program at 23. In fact, it's from the Mendon area, like Mr. Matthysse is. He did an outstanding job, and I told him he might have made the road easier for the next people. But this case is full of immature, impulsive behavior. The other issue is the logistics of doing this. If he's going to be working second shift at International Paper, that he won't be able to participate without considerable grace from his employer. So one option I discussed with Matt is starting him on a regular sentence with a probation, and I can always amend it and transfer it to sobriety court. But I don't think we've worked out the logistics from his job. As I understand it, what are your hours at work?
I usually work 3 to 11, sometimes 3 to 3.
And would you elaborate on what you told me in the conference room?
So I talked to my supervisor and she said, as long as somebody, which I already talked to them and they agreed, the shift before will stay after so I could do my Zoom calls.
We've had people from International Paper. We had one guy, and they were working 12-hour days. He was in our program and the company worked with him. And we've had another one, at least one more, but that guy sticks out because he was working so many hours and he did manage to
12 hours?
participate in the
Easy.
program. At some point, the wheels fell off after he graduated, but he did, I think, complete the program. Ms. Strong mentions if you get convicted of this, your license is going to be revoked, meaning it'll be 5 years before you're eligible to get a driver's license back. One of my concerns is that she's been more interested in getting you into sobriety court than maybe you have been. Although you've been here each time, you've been polite, you've been respectful, you dress respectfully as though you take this seriously. We understand the session you had with Spencer Price yesterday was 3 hours long, which was a good sign that you were willing to engage and a lot of information was exchanged. And her goal, and I guess maybe ours, would be to change your behavior before you screw up the rest of your life, or worse, shorten your life with a tree one night. Having said all that, Miss Davis, what's your position here?
Your Honor, Mr. Mathisse's history is concerning. He's had alcohol-related and substance-related issues since his juvenile days. I guess what is bothersome as well is that Mr. Matthysse is aware that on August 26th of 2023, he was drunk at the Vikings clubhouse doing burnouts in the driveway, took off, hit a neighbor's yard decorations, took off again, crashed into some irrigation equipment outside of Three Rivers, admitted to marijuana use, that somebody had laced his marijuana at the clubhouse. Unfortunately, that case didn't get reported to his then probation agent because he was on probation at the time. It was sent for further investigation because of it being impaired with substances. And unfortunately, it wasn't followed up on until 2 days after he was released from his probation. So 2 days after being released, a new complaint came out of the office in March of 2024 for the incident that had occurred in August of 23. It frustrates me that he knew that he had been taken into custody or, that this was potentially pending, and yet he didn't say a word to his probation agent for, let's see, August through December, and then December through.
Duh. Why would he tell on himself? Who in here would
the middle just disappeared.
Right. And so I had to dig out the facts on that one. And it turns out that last year in October, it had to be dismissed because there had not been the follow-up regarding the substances that he had used. That being said, it doesn't mean that it didn't happen. He didn't get a conviction for it, but there were certainly a lot of concerning facts. And the fact that he didn't bring this police contact up to his probation agent during that first probation is very frustrating. And to add on to that, apparently the Secretary of State had still shown that second one on his record because he called the court complaining about his insurance.
Yeah,
costs.
this was screwy because they abstracted the case that he got dismissed and didn't abstract the case that he was convicted of.
And I wasn't certain on that. I mean, there are times where Secretary of State will they'll get the abstract when the warrant is issued or the ticket is issued. And then if we don't end up charging, we end up sending a letter to them saying we ended up not charging for whatever reason. But that was on February 21st of 25. He calls the court complaining. And then on 3/1 of 25, it's about a week later, we have this charge where he's out at a local bar drinking with his father. Dad takes him home, but then he, for some reason, decides to get in his car and do burnouts in the driveway.
To piss off his neighbors.
Yeah, and start his own car on fire.
Yes.
So I also noted from the dispatch notes that whoever called this in.
He didn't on purpose set his car on fire. She made it sound like he just set his car on fire. No, that's not what happened. But wait till you hear how he tries to put the fire out.
Said he usually races up and down the road, which is concerning. If this is a person who wants to have a license in St. Joseph County with the significant history that he's got, I have concerns. And he was also in the household where Mercedes Wyrick OD'd while awaiting the case.
Governor, how
Josh
is that
Myers.
relevant?
Because there are substance abuse issues in the family and him.
It's
And
not
if he wants
relevant.
to have a license in
No,
St. Joseph
Debbie.
County and drive around on these roads where we all travel, then I think we have a duty to make sure that he understands how serious we are about the use of substances when he's driving.
Whether his family has substance abuse problems or not has absolutely no bearing on his driver's license. I mean, if I got in trouble for every time my sister did meth, I would be in jail forever.
Well, when we were aware of all that, and Matt and I have been struggling with it, and you weren't in charge in 2023 and 2024. And this happened more than a couple of times where somebody would get arrested, they'd get released, that never got followed up on, and essentially that one was a freebie. And we were aware of the conduct. Then this one, yeah, he's out drinking with his dad. So apparently his father's not real worried about his circumstance. Takes him home, and then his parents are in the house, apparently asleep, when he's out burning up and down the road and sets his car on fire. Police put it out with a fire extinguisher, and he was very, very intoxicated. And his reason for doing it was because he wanted to piss off the neighbors. So when I said we're talking about immature conduct, that's what we're talking about, which makes me question whether he's mature enough to do this. So I guess the question is, do we just give him a jail sentence and wait till the next time? Or do we try to intervene with supervision to try to change the course? I agree with you, Ms. Davis. This is very serious stuff, and Matt has been struggling with it. We've yet to receive the report from Spencer Price, who I trust his judgment. He's an original continuing member of our sobriety court team. So one option is to just do a sentence. either give him a bunch of jail time, make him lose his job, put him on a traditional probation, or try sobriety court with the supervision. The plea was no contest to impaired, so the court is limited to 93 days. And there's a carrot. The carrot is a reduction of jail sentence and a potential license. So I understand your position on this and probably frustration. He did call the court during that time asking about the warrant. I don't know what the deal was between him and his probation officer. I guess he just assumed we knew about it. According to the notes from the clerk, defendant called October 7th. He just found out he had the warrant. He didn't understand how he got a successful discharge in his other case if he had this warrant. I told him we got the new complaint 2 days after his discharge from probation. So he then came in 2 days later, once he found out about the warrant, and presented himself. And Ms. Strong got involved. So
He turned himself in. That's good, Judge.
then the case gets dismissed. And then there was an issue about which was which. So he turns himself in. The warrant issues, and again, you were gone at this point. Warrant issues October of 2024. Defendant calls, turns himself in, gets arraigned, and 7 days later, whoever authorized it dismissed it. And then it never got rebrought. So are you outright opposed to the idea of sobriety court? Are you willing to take a chance? And if he violates, we've still got 93 days left to work with.
I'm not opposed to sobriety court, but I also have concerns that he's not going to take it seriously, and I don't want it to affect the other participants that are in there or set some sort of precedent that, oh, you can just try it, and if it doesn't work out, oh well.
And we've done that before under the theory that the worst we can do is fail. The other guy that worked at American or International Paper had 9 OUIL convictions. We tried it. He was a felon, and he completed the program. It didn't work out in the long run.
And I guess I would ask if the court consider doing some weekends of incarceration to maybe drive home the point.
I think that's part of Mr. Huff's recommendation.
Thank you.
But yeah, Mr. Huff, what's your thought?
Well, Your Honor, I think that both the defense and the prosecution bring some good points to light about Mr. Mathysse' case. And I think that, most recently, Ms. Davis spoke about the severity of the charges, which can't be ignored. I mean, that is important. And I'm happy that the state, the people are represented in that fashion. That being said, the research is very clear in regards to reoffending drunk drivers. And that is that with an ignition interlock device installed in their vehicle, they are much, much, much less likely to recidivate, especially in the short term, in the first few years after entering that conviction. And if we consider the alternatives to a sobriety court, we have a traditional probation, which we obviously have seen didn't work last time, and we have incarceration. Incarceration is going to cause Mr. Matthysse to lose his job, probably go back down the hill if he's trying to fight uphill as it is now with his substance use disorder, in particular with alcohol. Then taking a setback in another aspect of his life, no license, no job, probably not going to help that substance use disorder get addressed. So I do believe that it's appropriate that if Mr. Matthysse' work is willing to work with him in regards to the requirements of sobriety court, that he enter into sobriety court. However, kind of to piggyback off what Ms. Davis said, in regards to if he decides to not take sobriety court serious, I think that we should just immediately and establish at this point in time at this hearing that the alternative is substantial jail and no probation. If he doesn't take this chance as his lifeline, and that, you know, the court uses the analogy of throwing a lifeline out to somebody lost at sea and bringing them onto the boat. If he doesn't take advantage of that, then at that point in time, we just have to keep going to save the next person. And he's just going to get lost out there. And that's not the fault of the court. That's the fault of Mr. Matthysse for placing himself in the position that he is today. That being said, you know, I don't see any reason not to accept him into sobriety court to at least try it.
All right, Mr. Matthysse, you've heard what everybody else had to say about this. Probably hard some of it to listen to. What would you like me to know?
I think sobriety court would be good for me. I know I have a problem that needs to be fixed, and I think it would be a good way for me to not mess up the rest of my life and lose my license forever.
Or your life forever?
Yeah.
Yes, if I just give you 60 days in jail, which Matt and I have discussed, you'll lose your job, you'll get out of jail, and you won't be under any supervision. And you'll be drinking shots of Fireball and hanging out with your friends, and it's only a matter of time till the next one comes, because the first one didn't scare you. The second one, where you about killed yourself, didn't scare you. And then apparently didn't scare your father much either, because he's out drinking with you to the extent that you were a 2-4, and don't have any memory of what happened. Plus you were out there trying to purposely irritate your neighbors at 2 o'clock in the morning while your parents were home. Probably irritated them too. Almost burned your car up. You tried to put it out with a cup of water, which wasn't very effective.
He was doing burnouts and his tires caught on fire. So he got 1 cup of water. The police came and put it out with a fire extinguisher. He tried 1 cup of water.
Effective, and the state or the sheriff came out with a fire extinguisher and put it out. What was actually on fire was your tires, because of these burnouts you were doing in the street. All right.
Monica, thank
Let's
you.
try it.
Thank you.
The young man I'm referring to, I won't say his name, but he greatly impressed me. Sent me a nice email after his graduation. He's got an excellent sponsor who was a guy who was you once. In fact, everybody in sobriety court was probably you once. They were 23. They knew all the answers. But they didn't understand the questions. And it was fun. Going out drinking and going to Cowboy Up where the girls are and the people are hanging out and there's music. It's fun till it isn't fun anymore. And then it's a lifetime of sadness. So you have the alcoholism gene. You got dealt a crappy hand. Not everybody that has the alcoholism gene is an alcoholic, and you're supposed to use that. Not everybody that has a substance abuse disorder has the gene, but when you have the gene and you at 23 developed a great tolerance.
Thank you, Twitchy.
It doesn't just cure itself, it just gets worse. And we've seen lots of people that started out with great promise that turned out squander it. I ordered 93
Guys,
days
where are
jail.
they?
There's
Thank
1 day
you.
credit.
1 day credit.
Credit 1, there's 92 days to serve. Of the 92 days ordered, 88 are deferred. He got some weekends to do, scheduled by the probation department. This is expensive, but nobody has more disposable income, according to advertisers and demographic people, than young people that have a full-time job and live with their
Yay.
parents.
Thank you, thank you, thank you.
You can afford to be in this program. There's a $75 crime victims' rights fee, a $50 state minimum fee. I'm gonna cut the screening fee in half, because you've had your screening with Mr. Price. The attorney fee is 0. You took it seriously enough to hire your own attorney. $960 probation oversight fee. Matt, I didn't see it in here. Was there a police reimbursement? There was a voluntary blood draw.
I didn't see it explicitly in the police reports themselves, but maybe Ms. Davis can provide clarity in that regard.
I will look, that it's St. Joseph County Sheriff's Department always sends theirs in, so let me,
Sometimes it's contained in the report, and sometimes it's a separate report.
Separate.
And
yeah.
I looked at both, I didn't see.
I don't think they considered it an accident, and it was a voluntary.
There was a
blood draw,
voluntary
so
blood
I think
draw,
it's
which I think is $200.
Yeah, 200 even.
And we're gonna try sobriety court. We've got an interesting mix of people on there. We just graduated 2 very successful candidates. After about 14 months. Both did an outstanding job. We're about to graduate another one when we reconvene next Tuesday, the 17th, and you'll be there. This is a probationary sentence and I can amend it. If you're not able to do the sobriety court probation, I can alter the jail days to either more weekends or just more days, but I'm hopeful that you can do it. We have worked with International Paper in the past. So everything that goes with sobriety court, no drugs and no alcohol. Now, no drugs includes no marijuana. At one point you had a medical marijuana card, and I'm not sure what the reason for that was. I won't get into it here. Now you're over 21, so you could smoke marijuana legally as an adult. You're not supposed to drive, but it's certainly very common. You're going drug and alcohol free as a part of this probation. We want to get your brain cleared of controlled substances. Are you on any medication for ADHD or anything?
No, I stopped taking that because I didn't like how it made me feel.
Were you on Ritalin or that sort of
I
thing?
was Concerta, or no, Vyvanse.
All right, well, if you take medication that's prescribed, you're allowed to take it. But you
Very,
can't
very
use marijuana
stealthy,
either.
Arno. Very
If
stealthy.
we gave you a test today, would you be positive for marijuana?
Yeah.
All right, so you've been waiting for the hammer to drop before you started doing the stuff you weren't supposed to be doing. So the hammer just dropped. So we're gonna get a test and see where your levels are. And then they have to go down to 0. And if it doesn't work, I can just give the balance of 93 days and hope it doesn't happen again soon. No drugs and no alcohol. I didn't add those numbers up. 125 plus 50 plus 960 plus 200 is 1335. Do within 1 year. The sobriety court program entails several things. It includes starting support group, AA or NA, preferably AA. There are some other programs like Celebrate Recovery and some faith-based recovery programs. You're going to need to be in one of those. Again, you've been waiting for the shoe to drop to get into an AA program. You're going to need to. Most of the people in AA are older, although we've had a couple of young people. We had a young woman also that was in her early 20s, also smoked marijuana. And she's doing great, last I heard. People in the group live near where you live.
long as I'm
May
under
be able to help
something.
you get back and forth to some support groups. You can lose your driver's license for a period of time until you're eligible to get it reinstated. It would be reinstated after at least 45 days with the installation of an interlock device on your car. And Mr. Huff pointed out interlock is good for a couple of reasons. You can't drive your car without it. And it's a way for us to tell every day that you haven't been drinking because your car won't start. And if you test positive on your interlock device, we get knowledge of it. So it's an extra.
And that is why I hate doing YouTube judges. Right there. I hate that. I hate that. I'm not doing it no more. This is the last day of YouTube judges, guys. I'm not doing it. I tried. I gave it my best shot. But I am not doing this no more. I can't do this.
Tool for us to see, but it gets you the ability to drive back and forth to work, treatment, school, other limited purposes. Almost everybody in our program has their interlock. Be drug and alcohol testing as directed. As we often say, all we can do here is fail. Now, you understand how the prosecutor feels about this. So if there's probation violation issues or that sort of thing, they're going to be coming from that same place. Now, the goal when we get you in sobriety court isn't to beat you up. The goal is to lift you up. So there's not a bunch of negative. It's all mostly positive. You get hooked in with a bunch of people who are in recovery.
No, I understand exactly what you meant. And I'm so glad that you came here just to hang out with us, even though you've already seen this. That's a compliment. It's an outstanding compliment. Thank you.
But this is a big pill for you to swallow, and I hope you can do it. I will be impressed if you do. If you can't, you won't be impressed because you're going to do a large block of jail time and you'll have to get a new job unless International Paper holds this one for you. That job pays pretty well. They're paying in the 20s. There's lots of overtime opportunity. It's hard work and they can't find any young people who want to work there. They've almost always got job openings because they can't find anybody that wants to work steady factory work. How long have you been there?
Next month I'll be there for a year.
All right, well, that's something. What are you making an hour?
Right now I'm at $26.85.
And you're getting shift preferential, and are you getting overtime?
Yeah, I get overtime a lot, especially now because the guy on third shift, he's the only trucker on third now, so I stay over till 3 to help him.
You should be too tired to go out and do this. All right, Can you take this down? I want you to meet with Mr. Hoff. And I will gladly shake your hand and have my picture taken of you a year or more from now. You can complete this program. I'll consider it a success for all of us.
Thank you, absolutely. Thank you.
All right, thank you.
Okay, I was going to go to Judge Manning next, right? Because when I first started YouTube videos, she was my absolute favorite. So I thought I'd go back. Now, I haven't seen her stream for 3 months. So I was just going to go and do one of her old Orca where there's like, there's like 20 different inmates in different video cell, in different Zoom pictures, and she goes so fast. But then as I was getting there, I saw that Judge Stevens just streamed 16 hours ago, and I just changed my mind. And I'm going here instead, and I haven't seen this, but it's Judge Stevens. What can go wrong? How bad could it be? I love Judge Manning.
You've been busy.
Try.
I'm sure you have. You are? Trevon Brumfield?
He's in yes, name right now.
Brumfield? Trevon Brumfield. I don't see anything on him. What's he?
It's an unagreed.
Sugar. Oh, I'm so mad. Oh, darn it, guys. Yesterday, I was supposed to get Buckley yesterday. Or today, or still today for me. Oh, I didn't get Buckley. Oh no, Shannon Party had a case at Buckley today and I didn't get it. Listen, wait, let's just look, guys. Because Thurston County, they don't always take theirs down. You know what I mean? All right, I want to see them all. So we have 1, 2, 3, and 4. Let's see if they're all together. Okay, good. Oh wait, 10 hours ago. Change in course, guys. Change in course.
Thurston County District Court are in custody calendar for Wednesday. We have
In custody counter. That would not be correct. Hold on. I want to see if he has another one up. Hold on. Oh, come on. Ah. I'm sorry, Anthony's swearing in the background. All right, hold on. I'm looking for Shannon.
When you show back
Come on, Shannon. Where are you?
one way or the other,
That's not Buckley.
decision order to show
That's not
them.
Buckley. I'm an idiot. Hold on. So this is 2. Nope, that's not Buckley. Was that Milmore? I don't remember.
Yeah, I'm pretty sure it's just because we already had it 60 and I'm asking. And if you'll get you'll hear it's not.
Oh, that looks like her, doesn't it? Tell me that's her from the back.
Okay, so the child might have,
Just jury
When we
selection.
recess
That's
for the
not her.
day and for the noon period, you'll
Darn it.
depart the jury
That's not
deliberation
her.
room and proceed directly out of the courthouse.
Is it? That's
When
not
you
her.
return, come directly back to the jury.
2024.
But everything back in operation, it was like, let's do this.
Hold on. It kind of looks like her. It kind of doesn't look like her. Let's see if at the beginning.
Everybody, welcome to Thurston County District Court.
Hold on, let's listen.
I am Commissioner Paul Wool. I'm the judicial officer who will be presiding over this trial. We've asked you all to come in here today to select some of you, 7 of you specifically, as a jury in this case. All right, before we get started with my remarks and questioning, I'm going to ask each of you to please stand and raise your right hand. And do each of you swear that you will should not withhold information in order to be giving any reason? These are known as peremptory challenges. And you should not take offense if you are challenged, since the challenge is not exercised as a personal reflection on you.
I'm listening to see if he
This
says
is
the name of the case.
criminal action instituted by the state of Washington as the plaintiff.
Nope,
The
this ain't
plaintiff is represented by
That was 4. So now we just need 1. Come on.
Everything they do is under such a time. For like the longest time, they sort of did 2
11 minutes ago. That's Veterans Court.
So like the entire time they have that stress, everyone's trying to give them, and like these 2 teams just keep battling over the playoffs. Keep Falcons kept losing.
So far, like why aren't they all? Attorney is appointed on the other case.
That wasn't Buckley.
I can assure you.
That's
Exactly what
not
this is all
Buckley.
about, but nonetheless, I'll go along with what's recommended there, Mr. Freed. The hit and run will be dismissed.
So his offer says.
All you have.
Actually, Keep Falcons is by themselves. Because they just put too much money. Like, I won't lie,
That's
they-
Buckley right there, correct?
They put too much money into it, so the bracket and everything's on the other side.
Nobody in the courtroom, folks appearing remote, these proceedings
I
are
think
being
that's
live streamed
Buckley.
on YouTube to increase
But this
public.
is not it. Unfortunately, she's not locked up.
Not related to you, sir, Mr. Myers, which of
And so we're gonna print.
I'm telling you that much. It is gonna be good.
Oh, I'm so upset. Oh, maybe Judge Stevens will make me feel better. It was Superior Court. Let me just. Let me just try one more thing.
They're picking Team Falcons because they put much money into it. Like, yeah, but it's not as much. Like, Twisted Minds does not have as much money as Team Falcons. It's just gonna be very Team Falcons.
Not District Court. I need Superior Court, please.
Yes. Yeah.
Darn it.
By the way, it's so fun to watch. Just bring that to you too. It's fucking hilarious. Just do it. Like this guy actually might be the best.
I'll keep looking. I don't think it's there. All right. Gala. Yes. He's not listed as a Superior Court judge, but they said in the hearing that it was going to be in Superior Court. And they said it was going to be Judge Buckley. So let's watch John. Let's watch Johnny Boy and see if he'll make us feel better.
Really on the motion to revoke.
Shannon Party, Pardee.
Good morning, Ms. Brumfield. We call cause number 21-37943, the state of Texas versus Trayvon Brumfield. That's you? With Mr. Dusler, your attorney, and the state's attorney. Do you understand there is a first amended motion to revoke a probation that's been filed that we are going to be working on? So are you familiar with this? Did you have a chance to discuss this with your attorney? Is everybody ready to move forward? Yes. Raise your right hand. Do you solemnly swear or affirm that any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth? So help you God. So lower your hand. This states that on April 4th, 2022, in this court, you were sentenced to 7 years in prison, and that was suspended and probated for 10 years for the third-degree felony of theft. Do you understand what this is charging you with? And this indictment was handed up back in 2021, and it states that you were placed on probation on or about June 3rd, 2021 in Jefferson County, Texas. You committed thefts of a value of.
She's got 32 cases I need to look through to find what happened yesterday. I'm gonna find it right now, though. Don't worry.
Over $30,000, but less than $150,000, and it's like dirt bikes. You understand? All right.
We can proceed. Judge counts 1, 3, 9, 10.
Let's just, okay, 9. Okay. Was he an absconder?
Yes.
Okay. Well, let's do 1 then. 1. Number 1 states you failed to report to the Jefferson County Probation Office on or about January 31st and May 9th of 2024, which was in violation of the probation order, which required you to regularly report. Is that true?
Yes.
And are you pleading true to that voluntarily, knowingly, intelligently, and because it is true as it is alleged? Do you understand that a knowing and voluntary plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation? Your probation could be revoked and you could be sentenced from no less than 2 nor more than 7 years in prison. Do you understand? That's the gap we're looking at if you were revoked. So that's what you're facing, that range of punishment that I would be determining. If I follow, so do you understand by pleading true, that's what you're subject to? Knowing that, do you insist on pleading true to this allegation?
Yes.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Was he an absconder from May of 2024? Okay. How often was Mr. Brumfield to report?
Any alphabet.
No, but how often were you supposed to? Monthly or bi-monthly? Monthly. Okay. And when was he placed into arrest? When did he get arrested?
He got arrested this year in May.
Okay, so he was gone for a year.
Yes.
He
was in Carrollton and he had another charge and he got arrested.
Where?
In Carrollton.
Texas, near Dallas?
Denton County, and that was in January of this year, Judge.
Okay. So you've been in custody since January somewhere, but from May of last year to January of this year, you should have been reporting and you didn't. Would that be correct? Okay. 9 states you committed the offense of theft from person on or about January 11th, 2025 in Denton County, Texas. in violation of condition 1 of your probation order, which states you shall not commit a crime while on probation. Is that true? Are you pleading true to number 9, voluntarily, knowingly, intelligently, and because it is true as it is alleged? And again, the same thing. A voluntary and knowingly made plea of true to 1 or more violations of probation, that's enough to grant the motion to revoke probation. Your probation could be revoked and you could be sentenced to no less than 2, no more than 7 years in prison. Knowing that, do you insist on pleading true? Yes. I find you are pleading true voluntarily and intelligently, and you understand and appreciate the consequences of pleading true. All right. I think that's going to be enough here. Let me just look at one thing. Was there any restitution here?
Yes.
Because it's not in the judgment. It says restitution. There's nothing, restitution payable to, and it says not applicable. What the heck?
The motion reflects an amount of $4,752.50, Judge. That's about.
It's pretty frustrating. Washington is pretty darn frustrating. I can find the case in a couple different places, right? But there is nothing. Like I can't. It won't let me open anything to see the documents. There's no way. It just gives me the same thing. I can't open it. I don't know what happened. Oh wait, this is from 2018 anyway. But still, it's funny. I saw 6/11 and I assumed this one was it. No. She was in court on June 11th in 2018 too. But they won't let me open the cases to see the
Supposed to be from condition 33.
Well, restitution was ordered by this court in the community supervision order, but it's not reflected in the judgment. Probably what happened is it was to be determined later, probably, and we did the judgment immediately, and then this came after the judgment. I'll bet.
Sure.
But so what's the balance?
The balance right now is $3,312 restitution.
3,312
Yes.
and
50.
and 50. And that's to the complainant in this case.
Oh, yeah.
That's right.
Okay.
Cowboy Schwartz. It's a name I remember.
All right. No agreement. So go ahead, Mr. Dusler.
Well, it's obvious that he had problems in reporting, and he explained to me that he just had trouble getting transportation to do that, but he'll also address the court about it. We've got the new charge up in Denton County that has not been disposed of yet. So whatever happens here, he's still got to take care of his business there.
What were we talking about? A theft of what? What's this?
I don't know the details of it. But the ones there, I know it's pending, but he's admitted responsibility for it, and he intends to plead guilty to that. We've still got this restitution owed. He's a young man. He did not have a bad criminal history when we placed him on probation. The good news, I guess, is for a while he did report and he did make payments, and he has paid a significant portion of the restitution. And he's just asking the court to give him an opportunity to hold it in abeyance, let him continue to continue on probation, and maybe he can finish this stuff up correctly. And you'll be able to tell the judge in just a minute. He'll let you talk.
And where's the other crime pending?
Denton County Judge.
Can anybody tell me anything about that?
I'm looking at a report that reflects that on January 11th of 2025. There's a report that he was involved in stealing from a Domino's delivery driver some pizzas and wings. Whenever they went to arrest him on January 24th, is when that subsequent offense arose about him evading. So the theft from a person is from a delivery driver, Judge.
What does the state feel is in the best interest of justice?
Back when he pled originally, I'd offered a cap of 7 years. I felt at that time the 7 years was warranted just because of the nature of his background and all. Your Honor determined that restitution was a good idea, and I feel like I always understand why you move in that direction, Judge. Cowboy Sports was out. The money that we talked about behind his conduct and another individual's conduct coming over from, I can't remember that. I believe they came from a separate location because I don't remember these two defendants being locals. But they came here, they stole these dirt bikes, and they were caught in the process. They damaged that. That's where the restitution comes from. They were actually able to recover the items, but it's the damage that was resulted there. We had a probation offer on the other defendant, and I know that was a factor as well that the court determined to do that with Mr. Brumfield. So he was given really a third opportunity whenever he got this probation because he'd been in trouble before. And even though he was successful for a period of time, he's right back to committing the same kind of criminal conduct. He was an absconder, just failed to report to us for a period of 7 months before he starts committing criminal offenses in another jurisdiction. Now, I know that hasn't been resolved yet, but it sure doesn't look good. And I would recommend that the court not continue this man on probation. That I originally argued for 7 years. I have yet to see anything that warrants any consideration for some time less than that. So I'm going to stand by that.
From probation, anything you would like to?
Originally, when he went on probation, he was sent out to Louisiana. He was a resident of Louisiana, and he stayed out there for a little while. But then he wanted to return back to Dallas, where he said he wanted to live at. But when he got out there, that's when he stopped. And then they didn't actually accept him in Dallas just because he had some other ones in Louisiana that he had to.
Thank you, Mr. Monroe. What do you have to say?
Oh.
If you want to say anything, Mr. Brumfield, this is your time. This is important, a very important point in your life.
Okay. I have the money to finish my obligation also right now.
What do you mean?
Well, right now, yesterday, when I was in my probation officer, Mr. Riley, yesterday, I made my parents a call to social security office, and that's so that's.
I don't hear you clearly.
Yesterday, whenever I see Mr. Riley, yesterday, Mr. Moore, yesterday,
Yeah.
I had made my grandma call the social security office and tell the social security office how much my balance right now. And they told me that my balance is for $4,650. And I said, okay. And the only thing I'm waiting for is to be released so I can get my money and get work hard and get my probation also. And whenever I was reporting and everything,
Well, where is the money?
The social security office have it.
Okay, here's, you're not going to get released to go get it. That's not the way it happens, because we had experience like that before. Trusting people, they leave, they never come back. We have to go find them again. And then when they're caught, it could be a while, but you're not going to get released until this was resolved. But I want the money's paid. That would help you. But you're not going to get out to do that. You're going to have somebody on your behalf do it. If that's what you really want to do, which I'll give you the opportunity to do that. But you're not going to get released. You're going to have to work through somebody else, family, or somebody you can trust to get that. And you get it, and you get that resolved. I'm not going to just let you lollygag around on it. I mean, you just have days, not weeks, days to figure that out. But I want the certainly the restitution to victims. That makes a difference to me. That's one way to fix it. Plus, it benefits you in sentencing. I reward people who can do that, even at this stage. But you're not going to get released to do it because we have a bad experience with that. And we're not going to go try to chase somebody again that, not that you do it, but it's happened before. So somebody's ruined it for everybody else. So that's not what we learned a lesson. If you can get this restitution, I can give you 1 week. 1 week. If you can do it, get it done, get it over to probation. We'll come back, pick this hearing up over here, pick the hearing up where we've left off. And you and anyone else like this who pay the restitution back, the court rewards them. But it's still, you're going to pay it. You're going to pay the consequences here, but you can minimize it to some degree by paying the people back. Are you going to be able to do that?
Yes, sir. The only way I can pay my probation with you, unless I have to go to in front of the Social Security office.
I'm talking about the restitution.
Yes, sir. I have to go in front of Social Security because they don't want nobody else but me because my mom or grandma tried to go up there and instead so that they want me to go in front of them so I can.
Well, I'm not going to let you. I'm not going to. I can't release it for that. If you took off, it happened again. Y'all got to figure it out somehow.
I don't think he's going to be able to access his funds. They're going to make him do it in person. And I'm not even aware funds exist, to be honest with you, just based on what he's saying.
Yeah. Well, you're not going to get released for it. You got to figure it out. If you can do it, I'll give you a week to try to get it done. Maybe your family can get the money together. And then when you're able to, you can go give them back that money when you are released sometime in the future. But no, you're not going to be able to amble about to make business arrangements and take care of business needs like this. Not when you've got an evading arrest. You've worn that freedom out while you're on my probation. But you think they might be able to help you in a week, your family?
No, sir, because they won't, because the Social Security, because whenever I went home in 2022, I had to go in front of the Social Security office so I get my full $28,000. I had to go in front of them.
Judge is asking you if your family, your mother and grandmother have the money otherwise. Could they get the money to pay your restitution and then you get out and get it from Social Security? Would they have the ability to come up with that kind of money?
The only thing they can try to come up with is my plan, so I can go home and try to get my money back. That's one thing they have to try to do, so I get my money back.
So I don't think it's gonna happen, realistically.
Okay. Yeah, let's
You can reset it, I think we're kicking the can down the road, to be honest.
Yeah, what we're not calculating into this conversation is the fact that Denton County has a hold on them too, Judge.
Yeah, you wouldn't be able to get out anyway. He says they've got a hold. you wouldn't know. You wouldn't know that. He would.
He's got to resolve those, otherwise they're not going to just let him, like you say, amble around them.
Yeah, go ahead.
Oh, I don't have it hold because.
All right. No, it's not a debate.
No.
They know,
I know.
they know if they have information that says there's a hold from Denton County. And as long as that is, and he's good for his word, they know that, then they alert the authorities. Now, they may release that hold, but right now, he says, and he's good for his word, there's a hold on him out of that, on you out of that Denton County. Which is a problem for you. You got to take care of that one way or the other after this. But once again,
Me, what did I do?
if there's a way you can
What did I do?
get
I'm
it
not even
paid
doing
through
anything.
your family, the court would reward you. But you,
Someone tell me what I
if
did now.
that's not
It's always something.
that's realistic, we got to move forward today. And I can always, if the court sentences you to confinement, then I can always change that judgment within 30 days. If something happens, I can bring you back and I can change it and for whatever you might be able to get done on your behalf. But you're going to be in custody if I sentence you. You're going to be in custody for the next 30 days.
I think that's appropriate. Go ahead and do that, and then we got, you sent 30 days to try to.
On people on his behalf.
Yeah.
It's, I know you're talking about Social Security, but I think I can't speak for him. And, but I know sometimes government agencies can be hard to deal with, but it's also been my experience that people over believe that too. Quite often the government authorities work with people a lot easier than they thought, or people on their behalf if people on their behalf or close relatives who have proof and information of what they're doing and why they're doing them. And it's in the best interest of justice, and they seem to work together when that can happen, but not always. Nothing further. I'm going to find there is sufficient evidence supporting this first amended motion to revoke probation to granted by a preponderance of the evidence or greater. As allegations 1 and 9 have been proven true. And did the state want to add anything else?
No, Your Honor, I've made my best argument.
And you're asking for
7 years.
And Mr. Dusler is asking to continue you on probation in some way. Again, there is sufficient evidence supporting this first amended motion to revoke probation to granted by a preponderance of the evidence or greater. As allegations 1 and 9 of the first amended probation have been proven true, as you have pleaded true to those voluntarily, knowingly, intelligently, and appreciating and understanding the consequences of pleading true. Your probation is hereby revoked. You are hereby sentenced to confinement in the institutional divisions of the Texas Department of Criminal Justice to serve a term of 6 years and restitution.
So I was trying to find Shannon Party's stupid court case, and I have like 30 different tabs open, but not in one. They're separate, and I had to search through all of them to find my StreamYard again. That's why the stream kept going blank.
Is ordered in the amount of $3,312.50 to the complainant in the indictment in this case. That will be placed in this judgment. And that's the finding of this court. If something can be done on restitution within 30 days, let me know. And we'll see what we can do about rewarding you somehow. Anything else? That is all. Thank you. Next is Mr. Calhoun, Chad Calhoun.
Mr. Calhoun also wants you
He's
to
also
let
interested.
him go so he can lollygag and find money.
Hey.
Is there some probation orders for Monday? We should not say the
I didn't, and I don't have anything, I didn't get anything from you.
That's all.
Oh,
You're saying there's nothing? Yeah.
you actually do need him.
Then it's the best kind if you don't remember it.
Heard y'all got a new director.
That's what I heard too.
There's a new director.
Yes, sir.
Coming in town.
Yes, sir.
Well, we're gonna, it's Jared, but we're gonna welcome Peggy.
Oh. Tom.
Okay, Chad Calhoun?
Yes,
Is that
sir.
you, sir? And we call, cause number 20-34315, the state of Texas versus Chad Allen Calhoun, here with Mr. Dusler, your attorney and the state's attorney. There's a motion to revoke unadjudicated probation that is on file as of April 3rd, 2025, and we're going to proceed on that.
Yes, sir.
And Mr. Calhoun, raise your right hand. Do you solemnly swear or affirm that any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lawyer. In summary, sir, this motion alleges that on December 16th, 2021, in this court, you were placed on 5 years deferred or unadjudicated probation for the state jail felony of burglary of a building. Is all of that true?
So, count one, two, whichever one.
One states you provided a urine sample on or about February 25th, 2025, which showed the presence of methamphetamines and amphetamine in your system. And that was in violation of number 10 of your probation order, which is do not use or possess any drug. And is that allegation true and correct as it is alleged?
It is very so.
Are you pleading true and correct voluntarily?
Yes,
And
sir.
because it is true.
Yes, sir.
Do you understand that a plea of true to one or more violations of probation, a voluntary and knowingly made plea, that's enough to grant the motion to revoke probation. Your probation can be revoked. You can now be found guilty and you can be sentenced up to 2 years in the state jail. Knowing that, do you insist on pleading true?
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes, sir. Very much.
Okay. Let's see. Yes, sir. An agreement has been reached here where you would be revoked, found guilty, sentenced to 1 year in the state jail. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Show you what's marked here. States Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney or the
Yes, sir.
contract you're doing for? States Exhibit 1 tendered into evidence without objection admitted. This states that all the parties, including you, understand that if I follow this agreement, you have no right of appeal. I'm going to do that. Well, let me ask one other thing. This is something I've noticed here. I guess it's under the order that states reimbursement fees. Those are probation fees. Is that what that is? That's what I've never noticed it before. Reimbursement fees. That's not restitution.
No, sir.
No. Okay. In the order, in the deferral.
Can you show me? I saw it.
It's entitled reimbursement fee / supervision fee, Judge.
Okay. I'm not familiar with it on the judgment, maybe if I saw the probation.
Yeah, but it's not restitution.
No, sir. There is no restitution on this.
Oh, I'm going to follow this agreement. If nothing further, I'm going to find, sir, you are pleading true voluntarily to a violation of your probation. You are doing that. You understand it and appreciate the consequences of pleading true. That is enough to grant this motion to revoke probation. Your probation can now be revoked. I hereby revoke your unadjudicated or deferred probation that you have been on. And this motion is granted. Earlier in this case, you pleaded guilty voluntarily to the state jail felony burglary of a building. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in the hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of the state jail felony of burglary of a building. I am following this agreement. You are hereby sentenced to confinement in the state jail for 1 year. You will be given credit, of course, for all time you have served in accordance with that charge.
Yes,
Do you understand what has happened today?
yes, sir.
Judge, before you pass that aside, I've double checked. There is a restitution amount on this. It is $5,000, and I know you are on that. What your typical rulings are, and I wanted to clarify my mistake.
Okay, maybe that was something, I don't know. But here in the probation order, there is restitution is owed the states in the amount of $5,000. Was anything paid on that?
He paid $572.
572?
Yes, sir.
So it's 572 less of,
His balance is $4,427
4428.
on restitution.
all right, restitution is hereby ordered in the amount of $4,428. That will go to the complainant in the indictment, Rodney Graddick. Do you understand what has happened today,
That
sir?
part I would like you to explain, please, sir.
Huh?
That part I could use a little I'd like to know what that means, sir, please.
That means that you still owe $4,428.
Yes.
It's in the judgment.
He would have to.
And
It won't cost you any more time in jail.
Yes, sir. Thank you.
But it will cost you the money.
Yes, sir.
Yeah, they can,
I can.
somebody can file a civil suit now against you, and that would be it. And if they get the judgment, which is normally just pro forma, it shows up on things that when you try to purchase a home or get credit, that can be used against you. But also, it was determined that was the loss, and you're getting a deal out of this. At the end of the day, that's half of what you could get, and it's at the end of the day, it's up to you. But the right thing to do is to pay people back.
Yes, sir. Very much so.
That's the right thing, and maybe maybe your conscience bothers you, like I hope most people, and you'll do something about it and fix that.
Yes, sir.
That would be the right thing to do all those, but that's your soul,
Yes, sir.
not mine. Also, anything else?
No, sir.
That is all. Thank you.
Need your right thumb,
Yep,
sir.
we need your right thumb. Theodore Follow is going to be
Now I
next.
feel like I need to go apologize to someone for something because Judge Stevens says it's the right thing to do. Go do it. Okay, if you didn't watch my stream about the 2 days ago, Shannon, this will make sense to you, but it won't make as much sense. It won't be as good. So I'm trying to find the court from today or yesterday, whatever. And I can't, okay? But I did come upon this juicy little another case that they have going on. And it's long, so bear with me. It started in 2023 against Jeffrey. I don't know who Jeffrey is, and I don't know what the problem is. But it is both William party and Shannon party, okay? And William is the lead attorney for both of them. well, okay, I should say William was the lead attorney for both of them at the start of this case in 2023, right? I have shown you cases with a lot of things happening, and usually, that means it's crazy. But this is next level. Just to show you what I want to show you is crazy. So normally when I go to a government portal, when I see complaint, I can click it and I can see the complaint. Washington is very frustrating. Washington is not letting me see anything that I want to see. But so William started out as, I wonder if this is the hearing that I'm looking for. I have a bear. Well, look, I have two bears. Koala bears. I know they're not real bears, but look, CJ made these for me. Anyway, so this is against Eden Trucking. Now, if you remember, and I don't know if this is right, but if you remember, the neighbor runs his dump truck constantly. We know this because she posted it on Facebook all the times that he did it. So this could be against him, but I don't think it is. I think this is a different case. I don't know though. I really, really don't know. So all right, right here, summary judgment. All right. Sanctions. There's a lot of sanctions. All right. Okay. In July of 2024, motion to disqualify plaintiff's counsel. That's William. Motion to disqualify William. All right. Motion to disqualify William. I'm just gonna go down because it's down further. This is crazy. No court cases like this, guys. We're still trying to disqualify the counsel in September. And sanctions. I don't know what the sanctions are. Still trying. Okay, now William wanted a summary judgment for Shannon on this. Okay, hold on. Okay, I passed it. It doesn't matter. I'm just going to tell you. He was disqualified. He is not allowed to be his own counsel. So I think they had to get a new attorney somewhere in here. There's too much to read through it. But they did do that. They took him off. And I'm looking. Long story short, I can't find it during the middle of a stream. They won. The trucking company won. Right now, it's still going on. But he was sanctioned and he was taken off this case. All right, order granting summary judgment. Eden Trucking Company. And then we have another hearing after that. Oh, that's why. So they won, they granted the summary judgment, but now they want sanctions. And this looks like a defendant. Motion for sanctions of defendant. That's the other attorney. So I don't know if they are both getting sanctioned or what. I just wish I could click these and look at them. I just want to look at them, please. I want to show you where he got kicked off the case, and I can't find it now that I oh yeah, here we go. Summary judgment at the court's request. Oh, the cancel to disqualify William Pardee from representing himself. Motion to disqualify William Pardee. Oh man. I wish I could see this case. And I don't think it's the same case because, well, it could be. It's possible it's the same case because the last thing that's listed in here is, just last month, less than a month ago by a couple days. And court records do not get updated that quickly. So if something happens today in court, you just can't go onto the website and see. You have to wait a couple days until everything gets entered. A couple days, maybe. A month, I don't know. So that's probably not the case, but it still says that he is the lead attorney. So I don't know. I just don't know. I wish there was more information. But there's so many cases with these. I can't get something that's not there. I can't just open something that's just not there. This is just a word. I can't link this word to the actual papers. The papers have to be there. I don't know if she went back to her maiden name. I have no idea. But there's so many cases. What did I miss? That looks like a name to me. What? Oh. I see my problem, guys. All right, I just did it from 2022, even though we know that she had cases open in 2018. We know there are more. But this is just from 2022 on. It's just the last couple years. And it looks like it is really them. It's not other parties. William. And where you see William, that's also crazy woman. Crazy woman. That's just that, by the way, that was just in I don't know what county. That could be her maiden name. Yeah, there's probably double or triple the amount of comments. I mean, the amount of cases. But let's go back to Judge Stevens. I'm done looking for them today. Hack what? Hack chat? You want me to hack chat? YouTube chat? That would be pretty difficult, but not impossible, just very difficult. Who are we hacking in chat? Are we going to make people say things? Because that would be hilarious. I would pretend I'm Maiko, and I wouldn't use any punctuation in the whole sentence. I wouldn't use any capital letters. I would say ain't with no apostrophe. Pierogi, he's okay.
Straight up. I did two more, same thing. Wait.
It's one more signature off, sorry.
More.
Theodore, is Foley your father?
You need, well, yes.
Yeah.
Hold on.
Jared, still not being extended.
Say that again. Why is it hard to, why would he be hard to locate in TDC?
I had to, like, he'd be in there and then another time grabbed him, and then by the time I did the next one, out.
He was moving around.
Yeah.
Come on up, sir. Thank you. We now call 22-41026, the state of Texas versus Theodore Lee Foley. Is that you?
Yes, sir.
Am I pronouncing it right, or is it Foley?
It's fine.
Foley. And you were here with your attorney, Mr. Dusler, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes.
So there is an indictment that's been handed up in this case as of, gosh, November of 2022. That's 2.5 years ago. And this states that on or about October 9th, 2022 in Jefferson County, Texas, you committed the 3rd-degree felony of unlawful possession of a firearm by being a convicted felon from a previous felony in 21 out of this for the 5th anniversary of your release from supervision under confinement following conviction by previously being convicted, I guess, of unauthorized use of a motor vehicle in this court. So you were convicted on April 19th of 2021, and this states that.
Hey, thank you so much, but I don't understand the K. Thank you so much. I really, really, really appreciate it. But wasn't it horsefish? Did you change it to horse fisk? Where did the K come from? Right? It used to be horsefish, right, guys? Right? Horsefish? Now it's horse fisk. We miss you. We really do. We really, 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 really do. And I appreciate you being here today.
Like a year and a half later or so, in October of 2022, you illegally possessed a firearm after that conviction. And so it's a 3rd-degree felony, which means if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range applicable? An agreement's been reached where you would be pleading guilty, sentenced to 4 years in prison. Is that your understanding of the agreement?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yeah.
You understand? Huh?
He wants to make sure it runs with the time he's already served in TDC. I've explained to him.
They all run concurrent unless otherwise specified by the court.
Experts who do
judgment, which would be running consecutive. And I don't see that's the agreement to run consecutive. So I'm not going to say the word consecutive, which means it's going to be run. And if I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
No, I'm guilty.
Nobody's forcing you to plead.
No.
I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Understand it? Discuss it with your attorney, or the contents correct? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No, sir.
Without objection admitted. The state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. An indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true and state, so help you God.
Yes, sir.
State's Exhibit 1, made a part of the record for all purposes without objection. Pre-sentence report is away?
Yes, sir.
If nothing further to add, I'm going to make the following findings that, sir, you have pleaded guilty today voluntarily and you are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now so find you guilty of this third-degree felony of unlawfully possessing a firearm after being a convicted felon. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years upon my finding you hereby guilty of this offense. Do you understand what has happened today, sir?
Yes, sir.
Need a thumbprint.
Just need your thumbprint in a minute.
Yeah, it's still around. Cool. Hey, guys. It's still. Getting on fun. It's fine. Same name. You. Your name back here, Tom? Yeah. That's awesome. They got him in, but he passed away. You know. I represented him in the past, so I felt like he was fun. It's good. Straight up and just there were 2 more things and yes. Some of these also good. No, let me watch Dungeons. Wonderful. I'm sorry.
Thank you, sir.
Richard Gill will be next. Richard Gill.
This is a motion of the military.
Dad from Hall, she signed up ready for me.
Okay. Yeah, it's not on the docket. Okay, good. Okay, thank you. All right, we now call Richard Gill.
Yes, sir.
That's you, sir?
Yes, sir.
In 24 CR 1240, you were here with your attorney, Mr. Dusler, and the state's attorney. There is a first amended motion to revoke probation filed as of May 21st, 2025. In this case, are you familiar with it?
Yes, sir.
Awesome. Are we ready to proceed?
Yeah.
Mr. Dusler on his behalf. Raise your right hand, sir. Do you solemnly swear or affirm any statements that you're going to be making during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Can we proceed in summary? Does he waive a formal reading of this?
Yes.
In summary, sir, this first amended motion to revoke probation states that on October 7th, 2024, in this criminal district court, that you were sentenced to 10 years in prison, and that was suspended and probated for 10 years for the state jail felony of unauthorized use of a motor vehicle. Is all of that true, sir?
Yes. Counts 1, 4, 8.
8 states that you committed the offense of failing to ID as a fugitive with intent to give false information on or about May 2nd, 2025 in Jefferson County, Texas, which is in violation of condition 1 of your probation order, which states commit no offense against the laws of this state or any other state of the United States. Do you understand what this charges you with? Is this true or untrue? Are you pleading true voluntarily, knowingly, intelligently, and because it is true as it is alleged? Do you understand that a voluntary and knowingly made plea is true to one or more violations of probation? That's all it takes to revoke your probation. Your probation can be now revoked and you can be sentenced to no less than 2 nor more than 10 years in prison. Do you understand? Knowing that, do you insist on pleading true today to this violation? I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. Is there any need to?
I hate when they do that. I hate when they're in orange and they're not. So I've been looking for this this one case from Judge McBurney, and I don't even know if it's good or not, but it was a year ago. And when I say it was a year ago, I mean it was somewhere between 12 months ago and 24 months ago. Okay. So somewhere in that year, there was an attorney that stood in front of Judge McBurney in the brightest orange tailored suit that I have ever seen. I saw it for just a second, and I've been trying to go back and find this one docket where this attorney is there in this bright orange, because look at her. It looks like her, only way brighter. Like magnify the brightness of her orange by like 30, and that's what you get. I even think, I'm not 100% sure, I even think his bow tie is that color orange. And I think that the inmate was also not in orange, so it was a reversal, just like this here. So if you're just looking at this screen right here, you would think, if you're just glancing at it, she's the one in trouble because she's the one standing in front of him in orange. But nope, it's him. I hope I can find that McBurney one. I think it's interesting. If not any, his outfit is outstanding.
Plead anything else? All right. Stand by. So originally, you entered your plea and were sentenced. This was a state jail felony of unauthorized use of a motor vehicle. However, you pleaded true back last October in this court when we placed you on probation to 2 other state jail felonies of theft prior convictions in 2023. So thus, that's why this is called a state jail felony, but it was punished because of those prior convictions as though they were a 3rd-degree felony. You understand? Okay. So that's why you're facing no less than 2, no more than 10 years confinement in prison for this, even though we're calling it a state jail felony because of the 2 other prior felony convictions that were enhanced or raised the punishment level here. All right, there is no agreement.
Correct.
Go ahead, for the defense.
Yeah, we should do that with children. We should enhance the punishment if they've had prior transgressions. We need to start, you know what we need to do? We need to create a whole new parenting workbook based on what we learned from the courtroom. I think if parents parented like judges rule, then kids won't mess around and find out. You know what I mean? We should work on this. We should all take a chapter. We've all watched a whole bunch of different judges. We have a wealth of knowledge on how to raise children correctly now. So we should all take a chapter and write a book.
Your Honor, he's asking the court to hold this matter in abeyance and continue on probation. This new offense occurred when he was stopped on suspicion of possession of drugs. He made a mistake by giving.
I got it. I've got it. Yes, ma'am. Sorry.
He realizes that he made a mistake by giving false identifying information, realized that was not a smart thing to
Thank you,
do
Ms. Faye.
at the time. But he feels like he can successfully complete his probation. We're not showing anything really, really bad right now. He is currently trying to rehabilitate himself from drug and alcohol use. He feels like with continued supervision from the probation department that he can successfully complete his probation. Is that correct, sir?
Yes, sir.
Is there anything else that I've not said that you want to add for the judge benefit?
Well, Your Honor, if it's, I would love to go to get some help.
Now?
If that's possible.
Well. Have you ever been treated before for substance abuse?
Yes. There was a while back.
When?
So this, 2019.
I don't consider that all that long ago. Oh, well, but where was that? What was
I'm so in love with my high electric bill. I love you, high electric bill. I love you.
the treatment?
Oh, this was in Dallas, Texas. So,
Dallas, how long were you in treatment?
for many days.
That's- It looks like you have a real prolific criminal history that I stuck my neck out on and granted you probation for. How many misdemeanor and felony convictions do you have?
350.
What does that say? That you don't even know how many convictions you have.
Well, convictions only have two. I have two felony convictions. Those.
You swear to God on that?
Yes, I only have two that I was arrested for, but no convictions.
I'm looking at 3 convictions here. Theft of property in Hardin County in 2017. You were placed on 4 years deferred probation for that on July 8th, 19, and another theft of property from 2018 in Hardin County, Texas. On that same day, you were placed on deferred probation in 2019 for both of those. Those were revoked in 2023, and you received 9 months state jail in each of those 2.
Yes.
Plus, this case, you were convicted of this and sentenced to 10 years in prison, and that was suspended, but it's a conviction. So you've got 3 convictions, including this one. What about your misdemeanors on what kind of, this was a unauthorized use, kind of a theft, a related theft. Do you have any other theft convictions or anything like that? Yes, you do. You got, in 2012, you committed theft in Ellis County, Texas. You were placed on 2 years deferred or unadjudicated probation for that theft in 2014. And the next year it was revoked and you were sentenced to 60 days in jail for that. Now, do you remember?
Yes, sir.
And then a misdemeanor of assault causing bodily injury to family. That was in 2015. You were placed on 12 months deferred or unadjudicated probation in 2016 for that. It does not show that that was revoked. So you must have served that out properly. Then you've got a failure to identify in Tarrant County. In 2015, you were sentenced to 7 days in jail. And let's go up to 2017 in Hardin County, 2 thefts of property. In February of 2017, in the next month, you pleaded guilty and were sentenced to 40 days in jail on each of those 2. You remember those now?
Hard, the 2 in Hardin County. The only ones I remember is the ones I went to state jail for. So
Well, it's too bad you don't remember, but the computer remembers. And then we round out the field with failure to identify. In 2019, you were placed on 1-year probation, adjudicated probation. That was revoked, and you were sentenced to 88 days in jail. That was out of Hardin County. Failure to identify, 30 days in jail in 2023. And resisting arrest in 2024, you get 44 days in jail, and those were here in Jefferson County, Texas. So I'm looking at 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 convictions in courts of record, including 3 felonies. And here we are. What's state say?
Your Honor, the state, based on the defendant's criminal history, he'd been given a chance before on probation. Obviously, he knew what he was supposed to do on this, and he didn't. He's got 3 new offenses while he's on probation, testing positive for cocaine. He's not reporting. Just about everything you can to violate his probation. The state believes the defendant not be successful if continued on probation. We're asking for 6 years TDC on.
Anything else?
No, sir, I believe.
Did you, Mr. Gill, this is your life. What do you want to say? Anything else you want to add? You got to fix all of this, you know. You got to start. I mean, it's in the record. So every time you commit another offense, it's piled on by these others things. These others add to the weight, and the law says it does. That's why you have to make the right choices from here on anyway, but it's just going to get more severe for you. Was there any restitution on that?
No, Your Honor.
No. Go ahead. Anything else? Nothing.
well, Your Honor, it all comes back to being addicted.
Yes, sir.
You know, so I can't blame nobody but myself. But you know, it's just being an addict is the hardest thing.
Yes, sir.
And I apologize to you, to my family, to everybody that I've hurt because of my addiction, but I apologize.
What do you intend to do about it, though? So we here in this case, we worked on with him on a substance abuse issue, didn't we?
So he was supposed to go to Franklin House, check us up every 30 days, never went.
Okay. So we tried to help you on that, but at the end of the day, you've got to pull your own weight.
Yes.
You know, it's up to you to make the choice, and it's you to walk the walk. We can only open the door of opportunity. You've got to walk through it, which you didn't do.
Yes.
Okay. But
Then he gets nailed for jaywalking.
this will pass. This isn't one of those cases that that whatever I sentence you on, you're going to be serving a long time. I wouldn't want to serve 1 day, but you'll get out. And then it's up to you to decide what direction you head in.
Yes.
And there are a lot of centers, placements that can help you, but it's got to be your choice. You made the bad choices that put you into this. You can just as easily make the right choices. It's climbing a mountain a little bit, but it's your choice.
Yes.
And you got free will, fix it. Because you seem sincere about it.
Yes.
But you've got to just don't talk the talk. Walk the walk that it takes to do the right thing and get it done. Fix that. Fix that. At the end of the day, other people aren't going to be able to do it for you. Yes, we'll make it available. It's available, but you've got to do the effort, the heavy lifting, like all of us do when we make mistakes to fix them. Okay. I'm going to find that there is sufficient evidence supporting this first amended motion to revoke it by preponderance of the evidence or greater. As allegations 8 has been proven true, as the defendant is knowingly, voluntarily admitted, and to a violation of probation, failing to ID as a fugitive with intent to give false information. And that is enough to grant this motion to revoke probation. Thus, your probation is hereby revoked, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years, which is half of what you were sentenced to. How much credit does he have?
First branch, I've given about 90 days. Going back.
You're going to be given credit for all time you have served in accordance with this. We'll figure out what it is, but this is not one of those cases where you are looking at serving half time, but there will be some time that you're going to have to serve before you are released. And hopefully the prison has opportunities available inside for people with substance abuse. They're supposed to. I understand they say they do. Take advantage of them when you can. So good luck to you. That is all. And
He's gonna need more than luck with those years. He's gonna be trained as a criminal by the time he's done with those 5 years. All right. We did good. But I can't do this anymore. I can't. I'm going back to my judges. This isn't I'm trying. You don't know how bored I was watching YouTube videos. And it's funny because that's what I used to do all the time. When I was watching Mike, when I was watching Law Talk with Mike way back at the beginning, and I think it's still the same right now, but I'm not 100% sure. First, I think that there are more judges that people watch than there was back in 2023. So, they've always been there, but more people have found more YouTube judges, right? So I think the channels don't all play the same. They all play the same YouTube judges, but there's a more variety on the channels now than there used to be. Back in 23, it was like whoever posted Judge Manning's docket first. They were all watching the same judges, and everybody tried to be first. Oh yeah. So if you look in Law Talk with Mike's Discord, I'm sure it's still the same. At any time between 8 and 5 during a weekday. As soon as something crazy happens, like everybody's in his Discord. Mike, something's happening in Judge Simpson's courtroom right now. You got to get it. Or Mike, check this out from Middleton. Oh my gosh. So, and then the content creators, they tried to post it first. They tried to post the crazy thing first, but they all posted the same crazy thing. So, and I was perfectly fine being one of those people that, I still don't think I never, ever gave him one of the big judges. I never said, Mike, look at this from Judge Middleton. Look at this. I did Colorado because there's a couple judges from Colorado that stream, like Khan. So I would send him that. I would send him Oh, I can't remember. Oh, I love this judge so much. He's the one that sounds like he's from New Orleans. He sounds like he has thick Cajun accent. Oh my gosh. I can't remember his name. Anyway, but I would send him that. Judge Oakley is amazing. I love Judge Oakley. But now when I try to go and watch YouTube judges, I just get so bored. I don't know why. It's still a courtroom. It's still court cases. But when I was trying to give you guys Judge Manning and Judge Middleton and that, I'm watching these and I'm like, I was bored out of my brains trying to get these. Oh, happy birthday to your eldest security, 37, man. Ooh, what a great little decade. The 30s. Remember your 30s? I had a great time in my 30s, but there was a lot of kids involved. I had a better time in my 30s than I did in my 20s. That's for damn sure. Anyway, I'm going to get to O.J. Simpson now. Yeah, and then he's gone, and it hurts. We have a hole where the judge used to be. Oops. Anyway, I have OJ set up, so I shall see you all very soon, or tomorrow, or later today, or in 3 weeks. Who knows? Be good, guys, okay? I don't want to see any of you in court. I want to see you all again tomorrow. And to those who popped in today who haven't been here in a while, we missed you, and we're glad that you stopped in. Thank you. Bye, Mika. Bye, guys.
Got this life that goes digital dreams through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a wake, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no